So, what are some of the legal protections that prevent re-traumatization? And first of all, I would say that by no means is the system perfect. There are traumatizing aspects to the system, shameful aspects to the system, or aspects that cause the youth in the system to feel shame. And sometimes there are things that are done and legal protections that exist to try to prevent re-traumatization. But it doesn't happen in all cases. And certainly the fact that, going into custody is one of the potential outcomes of going through the youth criminal justice system that is, has a traumatizing effect on the young person. And that is something that exists in the system. So, as I said, you can be held in pretrial custody or in custody after a sentence, depending on, whether you can get bail in the system, or if you have been convicted. There are offenses that a youth could absolutely be sentenced to custody for in Canada, and there are youth that are serving custody right now, and they're serving it in a youth facility, and those are designed to try to be as supportive as possible with social workers and schools right in the custody facilities. Counseling, access to healthcare, different things that would make the time in custody less traumatizing. Also, there's something called open custody, so that resembles a home more than it does a jail. Although, again, you're not allowed to leave at night, and the rooms do have locks on them, like barred locks. So the rooms themselves do resemble jails, even though the facilities resemble houses. But those even though there are things that are done to reduce traumatization, that is a possibility of the Youth Criminal Justice Act, that there may be a trauma caused as part of the execution of the legislation. Another component to prevent re-traumatization, and one of the other sort of principles of the Youth Criminal Justice Act in Canada is trying to give a pathway for the young person to leave their offending behavior in the past. And that includes very high levels of privacy and protections within the law. So, a youth criminal justice proceeding is still an open court proceeding. So you could go into the courtroom and sit there as a member of a public and just see what's going on in a youth proceeding. But you wouldn't be able to publish the names of who were involved. So that it wouldn't necessarily follow the young person through the rest of their lives if they put the offending behavior behind them. If you're charged as an adult in Canada, your name can be published and associated with the charge that you have and the proceeding that goes on, unless there's a specifically a publication ban that has been ordered by the court. But for the Youth Criminal Justice Act, your name is not to be published by default, and then the records after certain periods, access periods, are to be sealed, and you would have to bring a court order and satisfy a very high test to get into those records. So that allows youth, and so if you have an entry on your youth criminal justice record, it doesn't automatically become an entry in your adult record and doesn't show up if you stop getting any convictions before the age of, well, not convictions, but entries in your criminal record before the age of 18. If you do get adult charges when you're older and you're convicted of those, then it may be possible that those youth justice charges appear. But you're really given the opportunity to put that behind you before you turn 18. And how do courts adapt to reduce stress and anxiety for youth defendants? So courtrooms in Canada are often designed in a way to project authority and to create an environment that is constructed to create some stress. And you have the judge up on a dais, they wear a robe, the courtroom is a very formal place. There's a particular language, like jargon, that is spoken in the court with a high degree of formality. And all of those things are stressful, and even just sort of being charged, and the fact that the police come, and the person might have been in cell. There's all kinds of aspects of the youth criminal justice system that mirror the adult criminal justice system that create a stressful environment. So there has been, I would say, in many circumstances, cultural changes that are fed from some of those preamble principles in the Youth Criminal Justice Act that try to reduce the stress in a youth courtroom in order to make the situation less stressful, cause less anxiety for the youth. But that it's often led by judges and the prosecutors, and so it's sometimes individually driven. But I would say that my experience is that often in the youth court, you have judges who will speak to the young person in a less formal manner. You have Crown attorneys that are more understanding. They're applying the principles of the Youth Criminal Justice Act, but they often get streamed out of such a formal proceeding the way it is in an adult setting. So, but those, I think those things are not necessarily written right into the law. To an extent, they are if you apply the preamble, but you can apply the preamble in various interpretations. So it doesn't specifically say in the Youth Criminal Justice Act, that the youth should be spoken to in a manner that's relatable to them, or that it should be a more friendly, welcoming environment. But there are often situations where that happens, or the courtroom is constructed in a manner where the judge might come down from the dais and sit around a table, or when we're talking about Indigenous youth court, where they might sit in a circle that's more representative of the culture and less intimidating. Those are some of the strategies that get implemented to make the situation less traumatizing, less stressful. Another aspect of it as well is that there are often more support people, whether it's diversion workers or youth probation workers or social workers or youth mental health workers in the courtrooms. I mean, depending on the jurisdiction and the funding, but having those people in there to help navigate, to implement programming, often outside of it, but they will show up to the court date. That can be a source of reducing trauma and reducing anxiety for the young persons. But in my experience, often the young people are still very stressed out. They take the court process seriously, and they are afraid of some of the consequences, and it takes multiple court appearances for them to get a little bit more comfortable and have the court those strategies have an impact on them. So the procedural accommodations that are made to ensure the interaction with the justices are not harmful. So I think that happens sometimes. So for example, there's quite a bit of both written right into the legislation and case law. For example, that like a young person in our bail system. We have something called where there's when you're going to get bail, the onus is usually on the Crown, on the government to say why your detention is justified, why they couldn't release you on bail because you're innocent until proven guilty, and you shouldn't serve your sentence ahead of whether we find out whether you're guilty or not. So there's strong presumption that you should be able to be free out on bail. But there are various situations in Canadian law where that onus gets reversed back onto the adult defendant. Whether it's the particular characteristics of the crime that they're accused of, or the history of them. There's various factors where that onus could be reversed, and you would need to convince the justice of the peace that you're releasable. For a young person, that onus is never reversed. It's always the Crown prosecutor's job to, if they're seeking detention, to be able to justify that. So the cascading effect of that means that when the police arrest somebody, they are much more likely to release a youth than they would be to release an adult, because the law requires them to consider much more strongly whether they could, meet the reverse onus eventually, or the prosecutor could meet the reverse onus. Even when the police decide, okay, we can't justify their release, the prosecutor then has a second level. They need to justify whether they, and so that is a procedural accommodation where there's multiple levels, and then when you get to the justice of the peace, and there's a contested bail hearing, that's a third layer, and each one of those, they're much more likely than with adults to release the young person ahead of a pretrial. Then you have, but that's not, there can still be harm in having them detained, right? It can be harmful even to spend one night in cells. They could end up spending, many more nights because you're negotiating with the prosecutor about whether they're releasable or not. It might take you, often you will be able to get a contested bail hearing within 24 hours, but there may be situations where you're not. So there are various factors that mean that even with the best of intentions, or even with how there are procedural accommodations, there can be situations where there are traumatizing aspects, or there is some harm created.